A living trust is a legal arrangement where a person places assets into a trust during their lifetime. Think of a trust as a legal container for your assets and property. You can also appoint someone to manage the trust or do it yourself. The advantage is that you can maintain control of those assets during your lifetime, including the ability to modify or dissolve the trust. In this video, we're going to cover how to create a living trust in Alaska, the key roles of a living trust, requirements, and more. We're eForms, your go-to destination for legal templates and how-tos. If you're ready to get started creating your own Alaska Living Trust, click the link in the description below. Let's jump in. We'll start by defining a few key roles. First, there's the grantor. This is the individual creating and funding the trust. Next, the trustee. This individual manages the trust assets during the grantor's lifetime. The grantor can serve as the trustee if they are not the sole beneficiary. Third, the successor trustee. This person manages the trust assets if the trustee dies or becomes incapacitated. Commonly, the successor trustee's role is to distribute and transfer the trust assets to the beneficiaries. Finally, the beneficiaries. This is any person or organization who stands to inherit from the trust. Does a trust need to be registered in Alaska? Yes, it's required to register a trust in Alaska. To do this, you'll complete Form P-200 and file it with the trustee's local court. If a trustee doesn't register after 30 days of being notified to do so by the grantor, the trustee can be subject to removal from their duties. Is an Alaska trust revocable? Unless a trust mentions it's irrevocable or it's revocable, a trust can be amended in writing during the grantor's lifetime. If there's more than one grantor, each may modify the trust in relation to the property they've contributed. What are the signing requirements? There are no state signing requirements in Alaska. However, it is recommended that a trust be witnessed by 2 people and a notary public. Before we go, let's cover the steps to creating a living trust in Alaska. Identify property. The grantor should take an inventory of the properties to be entered into the trust. This can include real estate, personal property, retirement accounts, business interests, and any other valuables the grantor owns. Property and assets that are not specifically entered into a living trust will not become a part of it. 2. Choose trustees. A trust will commonly have 2 types of trustees. Initial trustee manages the trust during the grantor's lifetime. For revocable trust, this is commonly the grantor. Successor trustee manages the trust if the grantor becomes incapacitated or dies. They will be responsible for distributing the property and assets of the trust to the beneficiaries. 3. Select beneficiaries. The beneficiaries are the individuals who will inherit the trust property after the grantor's death. They're usually the spouse or family members of the grantor. Who can be a beneficiary? A beneficiary can be any person, born or unborn, or organization legally permitted to hold an interest in property. If a grantor wants to give a portion of the trust property to a pet trust can be created within the trust document. 4. Signing. To prove a living trust was created, signing with 2 witnesses and a notary public is recommended. Estate planning can be a complex process, but we're here to help. If you're ready to start creating your own Alaska Living Trust, click the link in the description below this video. Thanks for watching, and don't forget to subscribe for more.